This is Trials and Tribulations. Larry and I, heard that it was a cool thing to do a podcast, and so we're going to give it a shot. We're going to be talking about a lot of different topics. There'll be discussion about the practice of law, what it's like to move from being a lawyer to being a business owner, not within the practice of law, which is what Larry and I have been doing for the last 5 years. We're also going to talk about general topics, both legal and business. So if something is hot for the day in the legal world, we'll talk about it. We'll address it. We'll give a little background on what's going on and maybe some of our limited legal expertise. If there's something interesting going on in the business world, same thing. We're not experts in everything, but we can at least give a little perspective. So it's to open discussion, have a little fun, and just talk about what it's like to run this business.
And we'll definitely focus on the tribulations part.
Once you're a practicing lawyer, you're kind of always a lawyer. You can't really get that out of your
Yeah, it's DNA. A certain way that we've been trained, a certain way that we lived our life. It's a certain approach that, for better, for worse, sticks with you.
Right.
But I think, in large part, it's been for the better.
Well, yeah, because I think that when we first decided we were going to not leave, but modify the way that we practice, because I think we'll always have some foot in the practice, but when we decided to modify it to run this company, at least my thought was I was a little bit fed up with the practice. I was tired of arguing with defense lawyers. I was also concerned in this small community that if you're going to be people, you might run into people that your kids are friends with or that or at the school.
It's only a matter of time, yeah.
Right, so that worried me. So that was sort of one of the motivating factors. But the degree, having a law degree itself, provides so much value in business. There's so much that you don't even realize that you're using on a regular basis that, in fact, it can get frustrating as you try to tell other people that you work with how to go about things the way that you were taught, but they didn't have the benefit of 3 years of law school.
Yeah, it's definitely a benefit to us every day. And I can't even imagine running a business without having that legal background. In a way, it would make me feel vulnerable. It would make me feel really reliant upon outside attorneys to advise us, where I think we can be much more confident, even though we always consult with outside attorneys when things are specialized or outside of our area of expertise. I still have the confidence to interpret things on my own. And I think that allows us to make better decisions and feel more confident in the way we approach things every day. I think in other ways, though, we've definitely had to adapt. And we've had to learn how to think differently sometimes, how to approach things differently, because taking the lawyer approach isn't always the optimal approach.
Well, because there's two things. So there's the practice of law and how that applies to the way that you run the business. But then there's the business that you're running as a lawyer and how different that is to running a business like ours. So
it's night and day.
Right. So, it was a big adjustment. I'll never forget when we first left, quote unquote, left the practice and started this company, there were some people that we were working with that were harping on culture. And I don't know. For me, there's very little culture in a law firm, especially a small firm.
Oh, there's a culture.
Yeah, but it's
an archaic culture, and it's very much a binary culture.
Right, and that does. And here you have to adjust because culture matters so much in an organization like this. But at first, I was very resistant to the idea of figuring out company culture because it was totally foreign to me. They don't teach you anything about that in law school. Even in the practice of law or the business of law, it's almost non-existent, especially in a smaller practice. So one of the hardest things for me to learn and to understand coming into this business was how to adapt to the culture of an actual functioning business that isn't a law firm, how to manage people within that law firm, how to structure the tiers of management. That's a thing that, again, there is no training given to you whatsoever in the practice of law.
It's been a tremendous challenge. I worked in bigger firms than you did. So I'll say, I've worked in a couple of firms who had more or less the same size as our company right now. But when you really analyze it, you say, okay, a firm of 50 people, you have the lawyers, the senior lawyers, then you might have some associate lawyers, and then you have support staff. And there's really three, I'll say, departments. And if you're, managing the firm, you're not managing the other managing lawyers.
Right.
So you're managing younger lawyers and support staff, and that's about it. And the complexity of our organization, I think that's really been a tremendous challenge for us, because here we have marketing, we have sales, we have underwriting, we have data science, we have finance, and the finance department itself is split into like 3 different roles. And for us to be able to understand each one of those departments, understand each of those sub-departments, and then be tasked with managing all of those things, I think that's been such a challenge. It continues to be a challenge. And even if you're experienced running a law firm, stepping into this kind of organization, you can't even compare the two.
But I think one of the things that lawyers who would watch this would understand is there are these simplistic ideas that they teach you in law school that you don't ever really think are going to be applicable to real life. Like, one of the things that I have noticed about myself in managing this company is writing style and what I expect of the people that work here when they get me information. In law school, they teach you got to go to the conclusion first, and then you got to go to the reasoning. It's like your IRAC or crack. It's conclusion, reasoning, analysis, conclusion, or issue, reasoning, analysis, and conclusion. That type of style, for me, has become the only thing that I want to see and hear.
It's ingrained in us.
But for people who have not been through that, people who haven't been taught that, it's unfair to expect them to be able to provide that to you because they didn't go through that same educational process. And so, again, it's all about adaptability. And we've been doing this now since 2017,
it's been 6 years.
16. And I'm still adapting on a regular basis to figuring out how to separate myself as a lawyer versus a CEO and a businessman. And sometimes that's a blurred line, and it's sometimes difficult to make that separation. I think that's why I like doing the collection in this company so much, because it allows me to still be a lawyer, kind of, when I deal with customers who are having trouble paying or people who are in default, because at that point, I could put my lawyer hat back on and quasi-litigate and feel like I'm still doing what I used to do.
Yeah, well, it's not just the litigation aspect of it. Both of us are litigators. But I think what we've also, ironically, we've become better transactional lawyers since we've been doing this. I think back to the first transaction you and I did with Level, we felt extremely uncomfortable going over contracts, going over all these different kinds of agreements, and we completely relied upon outside counsel to do that for us. Today, we're intimately involved in all the transactions that we've done. And we've done major transactions with Level, and we've done major transactions with Idea, and you and I have been very involved in those transactions. We feel comfortable now going through the documents ourselves, making comments to our attorneys, and so it's been an ironic thing that we've developed our skills as transactional lawyers at the same time that we've developed our skills as managers and leaders of a finance business.
But what do you think? So I know a lot of lawyers who are practicing oftentimes talk about how they want to leave the practice, how they want to do something different because they have the same sort of feelings that we had. We've done it now for 5 years. For you, do you ever miss it? Do you ever feel like you want to be back in that world? When we go to these conferences like Mass Torts Made Perfect or any of the legal conference, do you ever feel like you wish you were on the other side back as an attorney as opposed to running this business?
There's 2 things that you bring up there. One is think about leaving the practice of law. I'd almost call it fantasizing. And I think most attorneys fantasize about doing something other than practicing law. And it's a fascinating topic that we should definitely get back into. As far as do I miss practicing day to day? No, I really don't. I miss aspects of being an attorney as far as being part of the community, because I think in every city, every region, there's a real strong community of attorneys. And I miss going to the different events, going to the different bar events. I miss, just going to court sometimes where you'd run into people who you haven't seen in a while when you're waiting for motion calendar. I really enjoyed that. I do miss that. And I think that since we've been doing this, since we've been building these companies and running these companies, there has been a little bit of isolation from that community that I think both of us sense in one way or the other. That's what I miss the most. But that's been replaced by so many other wonderful things that I don't ever regret it.
Yes, it's funny because for me, it's the opposite. Like, I always hated the social events.
I used to have to drag you to that stuff.
I hated going to like bar events. I hated small talk. I didn't like going to cocktail parties. It just wasn't my thing. You always liked it. I never did. I didn't like putting on a suit. I quickly got out of the suit. You kind of kept with the suit for a while. But I miss actually being in the courtroom sometimes. I don't at all miss the preliminary stuff. Like just now, I was talking to a lawyer because we're dealing with a collection matter. Number one, the first time I spoke to him, he told me that he was going to challenge ethically whether I'm allowed to represent Idea Financial.
Yeah, I remember that.
All right. The conflict is between Idea Financial and me, not him. So he was making up nonsense. The second thing he told me yesterday.
It was creative, though.
Yeah, whatever. The second thing yesterday, he told me that, what did he say yesterday? That our loan agreement doesn't require repayment.
Yeah.
So that was number two. And I dispelled that by sending him the information that showed that obviously his client's got.
Oh, you mean the contract?
Yeah, the contract.
Yeah.
And now today he wants to give me some sob story. I said, dude, like I told you, like this is the last opportunity for your client to pay me. And I'm going to withdraw the offer and we're going to go to court and that's going to be the end of it. The guy's an idiot. And he's playing games. It's all gamesmanship. It's all nonsense. It's threats. It's the kind of stuff that makes you realize why you don't want to be part of that group anymore because it could be so childish and childlike. But then once you get into actual courtroom and you're in front of a judge and you're making a compelling argument or you're dealing with something very serious, that's the kind of stuff that I do miss. I really miss that a lot because when I was in a courtroom, I felt like, I don't know, everything else sort of locked out and you could just focus on one item and only one item. And that to me is compelling.
That's certainly, I think most litigators, when you're at that moment, after all of the preparation, after all of the anxiety, and you're finally there and you're in the zone and you're performing and it's a theater and you're the master of that theater, that's almost, it's an adrenaline rush. And I do miss that, of course. But I think one of the fundamental problems with being a litigator is that that's such a small piece of what you do on a day-to-day basis, and the rest of your day is consumed with things that aren't so enthralling or don't put you into that moment. That's what can get a little bit exhausting and fatiguing, I think. But I'll tell you, I think that same feeling, we've replaced that when I look back on all the things that we've done and are continuing to do, those same skills and that same need to perform and to persuade, we've replaced a courtroom setting and sometimes with a boardroom setting.
No, you're right. I think that we have replaced a lot of what we dealt with courtroom-wise here. In fact, if you really think about it, you're right. The excitement that I'm talking about that I miss, it was 5% of the time.
If that.
And I think a lot of people who go to law school, they have this expectation that when they get out of school, that's what's going to be their life. And it's a total misconception. The media and movies have lied to people for years about what it's like to really be a lawyer. Being a trial lawyer is a grind, and it takes a lot of preparation. It takes a lot of work, a lot of reading, a lot of review. And that's the kind of stuff that can get very monotonous, I think. When you get out of school, I'll never forget my first job as a lawyer, I did medical malpractice defense, and I hated science as a kid. I absolutely hated it. I think I got my lowest grade in high school in science. And when I walked into my first job, they handed me a medical file because I was doing medical malpractice defense. And I had to read a bunch of medical records. And I called my mom. I was like 25. And I called my mom and I said, I don't think that this is what I want to do. I can't imagine sitting here and reading scientific records. I want to be a trial lawyer. But as I started to evolve and recognize that the practice had a lot to do with analysis, it didn't matter what you were analyzing, I was able to get through that. But it was a shock. It was a shock to my system to know that that's what I was going to have to do. And that sort of preliminary preparatory work, I think, is the stuff that trial lawyers get exhausted by. It's very time consuming. It can be all encompassing. And for the people that do contingency work, it's all or nothing type work too. Because if you don't win, you don't get paid. You lose, and you've wasted all that time. So there's a lot of pressure there that I think you can leave behind if you leave the practice.
Absolutely. But, to circle back on that theme of how we use that today, I think that the attention to detail that you have to develop as a litigator translates very well into the business world. And I think that if you don't have that formal legal training and legal experience, details aren't as important to you. I remember very early on when I was being trained in the first law firm that I was working at, I would bring things in to my boss and he'd throw them right back at me because there's imprecision. And that was probably the first major thing I learned at a law firm was precision. The details matter. Every single word that you use, every single title, every incorporation by reference, everything has to be absolutely precise. And I think that sometimes when we work with the different teams here, we demand precision. And some would say perfection, but I really like to say precision. And that's something that maybe we take for granted as part of our identity as lawyers, as part of the way we used to, live or die. Precision really mattered. And I think that relates very well, especially in a financial services company. Precision is absolutely critical.
What do you think? What have been the biggest challenges for you in making the transition from being a trial lawyer and working in a law firm to doing what we do here?
I don't think that there's one answer that applies through the whole experience, because what makes it more complicated is that the transition from being a practicing litigator and also running our own firm to starting up companies was one transition. And that had its own host of challenges and also enjoyment, right? We started 2 different companies. And they were very different in different industries, and both of those posed their own challenges because we had to learn 2 different industries almost simultaneously. So starting the companies up, getting them off the ground, getting them financed, that was one challenge. And then once the company started functioning and running, then we had to recruit. And then that was challenging also, recruiting the right people. We made some mistakes. Once we got that right, then we had to confront growth. And once we confronted the growth and got both the companies more or less stable, then we had to learn how to manage complicated organizations. So I think each one of those stages had its own complications, had its own challenges for us, and we've had to constantly evolve. So to say that we went from being practicing lawyers to running businesses overnight, we leave out all these other different stages that were completely different, that we had to adapt to and learn all these new skills and then move on to the next thing. So I think that we're constantly being challenged with new things that we have to learn, we have to confront, and we have to adapt to. So it's been a dynamic process for us, which sometimes can be exhausting. Other times when we take a step back, I think it's extremely fulfilling to see how far we've come when it comes to different skills. Thinking about challenges and going from being a practicing lawyer, being the owner of a law firm, to doing whatever it is that we're doing now today. So I was telling you about the way I perceive some of the challenges. What about you?
So the biggest challenge for me has been delegation of authority. As a lawyer, if you want to, and I did for many years, you can run your own business and be the only lawyer, and you can run all of your own cases, make all of your own decisions, and have impact on every aspect of the business. It's a pretty simple. When I say simple, in no way am I denigrating the complexities of the practice of law, but the business of running a law firm is not that complex. And if you want to be a solo practitioner, you can do that, and you can have no staff, and you can make all your own decisions and do everything yourself. In this business, you simply cannot do that. And the delegation of authority on finance, on underwriting, on risk management, sales, accounting, marketing, these are all departments that we can, except for technology, we can provide a little bit of information and input on each of those, but in no way can we run any of them ourselves. So finding people that we trust, which is very difficult to do, and we're very fortunate that we've been able to do, and then being able to delegate authority to those people and trust that even though we are not directly involved day to day with the things that they're doing that have such a huge impact on this company, that we can trust that they're going to do it well. Now I feel very comfortable, well, somewhat comfortable with that. I'm never going to be totally comfortable with delegation. It's just not me. But I feel a lot more comfortable today. At the beginning, I was completely uncomfortable with it. And I just simply couldn't get it in my head that I had to allow other people to do the work. And so that was a huge challenge. And I think any lawyer who's practiced in a small firm by themselves or with only a couple of other people would find that to be very difficult.
Sure, I understand. And it's a whole paradigm shift too, because typically your clients expect that you're going to be doing the work.
Right.
So it's almost a positive feedback loop.
That's very true.
But the other, that was difficult for me. Admittedly, I don't think it's as difficult for me. It's just maybe a personality difference. But what affects both of us then and today. It's still the responsibility, the accountability, because no one, I learned a long time ago when I first started practicing. I remember one of my bosses telling me, like, hey, listen, your assistant doesn't ever make any mistakes. When you have an associate, he or she doesn't make mistakes. You make mistakes. And I think we still both feel that weight, where if God forbid, there are mistakes made or something isn't done appropriately, ultimately we have to bear the brunt of that. And we both feel a supreme sense of responsibility and accountability. And that's the flip side of the delegation.
You're right. And that's the other thing, and you kind of lead to another area which is complicated and complex, in that as a lawyer, you are you answer to your clients, period. Obviously, if you're in a bigger firm, there may be other lawyers that you have to work with and answer to, but the real end user is your client. In this business, it's far different than that. I mean, we answer to the board. Even though we're members of our board, we're still ultimately reporting to the board in our positions as CEO and president. We have financial partners that we have to report to, multiple financial partners. We have investors that we need to report to. And we also have to report to our leaders and our leadership and our own executive team, because we're accountable to them. So the levels with which we now have responsibility to others is far deeper in this business.
Well, we've spoken about that before, maybe in a different context, but it's a unique phenomenon where when we were practicing together, we had a certain degree of autonomy. Yes, as you say, we were accountable to one another, which was very important. And of course, we have to answer to our clients. But there was a degree of autonomy that we enjoyed when we were just running that business. And as we've transitioned to running a much more complex operation, in some respects, the degree of autonomy decreases. And that's a kind of an unforeseen, strange thing that's happened that we've definitely had to adjust to.
Sure. But if there's one thing that I don't miss on a day-to-day basis, is being accountable to a courtroom and a judge. Because if I want to go on vacation here, I go, and I can work from wherever I am. But if a judge wants to call me in on a hearing, I got no choice. I got to be here. And I know people, it never actually happened to me, but my brother had a judge one time. His wife was having a baby, and the judge wouldn't grant him a continuance when his baby was going to be born. He eventually got it, but he had to go into court twice and beg for it. And that kind of stuff, if you get on the wrong side of a judge, or they're having a bad day and they don't want to give you time, which is for your family, they can just tell you no, and then you have no choice but to show up. And that I do not miss at all.
Yeah, that's a difficult thing as a litigator to live with, is that to an extent you're always at the mercy of the judge's scheduling. And I think COVID has eased that a little bit, in the sense that litigators can now appear by Zoom, and that's become more common. But I think that's retracted a little bit, since the height of COVID. And, I experienced it. I see it, sometimes over the summer if I'm away. Some of my friends who are with us, they're practicing litigators. And one of my friends over this, I think it was in June or July, had to fly to Utah for like a 10-minute hearing.
It's ridiculous.
And he was so pissed. And I understood that. And that was absolutely something I don't miss.
I mean, I remember when I was practicing, I had cases in the Keys, and for some reason the judges down in Tavernier, they did not allow you to appear by phone. It had something to do, I think, with keeping the local lawyers
working. Yeah, protects the local market.
So I would go drive 3 hours or whatever to get to that hearing. I would appear for 10 minutes and I would drive home. It was the most ridiculous system ever, but you have no choice but to show up, because if you don't, you could be held in contempt. The judge can make your life very miserable, and I don't miss that.
I don't miss that either.
One bit. But I do think you're right. Because right now we have a couple of these collection cases that we have filed through our law firm against companies that have defaulted on loans. And I have a hearing tomorrow in one of those. And I haven't been in front of a judge in, God, it's been 6, 7, 8 months. I'm looking forward to it because I haven't done it in a while. But I am so thankful that it's Zoom. Because one of the worst experiences for any lawyer is sitting in motion calendar in Miami. Broward also.
Miami's so much worse.
But going in there and sitting in that courtroom to have your 5-minute hearing heard with like 40 other cases, and then your opposing lawyer doesn't show up until, right after the hearing starts, so everybody else is in front of you, and you have to sit there for 3 hours. It's the biggest waste of time in the world. So being able to do that by Zoom tomorrow, putting it on mute and just waiting for the hearing to start while I do other work. That's a sea change that I hope never goes back.
I don't think that will. It's been, I think, a fantastic thing, especially in a jurisdiction like Miami-Dade, where it's the volume's not managed efficiently. There's just not the resources there to manage the kind of volume, not to mention the physical impediments of the courthouse that we have down here.
It's garbage.
It's embarrassing.
It's embarrassing. It's people have gotten sick allegedly from being in that courthouse because it's so old. It really is terrible. So that's these again. If we're talking about things that I do not miss, the waiting game of motion calendar, having to sit in that courtroom for hours waiting to be heard for 5 minutes, lawyers who don't show up on time, that don't care about your schedule, that kind of stuff I don't miss one bit.
Did you ever have the experience of, when you were a younger associate being responsible for 2 different hearings during motion calendar on different floors in the courthouse and having to run up and down those stairs?
Of course.
I get anxious just thinking about that. Oh my God.
So those are the things that I think no lawyer would ever miss. And I think it's actually the things that push people out of the practice, the inefficiency. I mean, this hearing I have tomorrow, we said it, I think 2 months ago. It's a motion for extension of time to answer a complaint. And I couldn't get a hearing date with the judge until tomorrow, 2 months ago. So you talk about the constant rolling inefficiencies of the courthouse.
Well, if you compare the experience of practicing law, and we're talking about being a litigator right now,
right?
Not necessarily.
So
being a litigator in particular, just anecdotally, when I compare our experiences versus, let's say, 20, 30, 40 years ago in Miami-Dade County, or maybe anywhere else in the country, I think that the passage of time has really affected the practice of law. And I've always, when I was thinking about it, again, this is just anecdotal, but a lot of the attorneys who we know who are maybe 20, 25, 30 years older than us, they had a different experience practicing law. And I think overall a more pleasant experience. And I think a lot of it does have to do just with population growth, increased competition, and decreased efficiency of just the judiciary locally. It comes together to create a really frustrating environment to operate in, where you just want the challenge, you enjoy the challenge, you appreciate the technical aspects of practicing. But when you complicate that with all these other factors, it becomes a grind, so to speak.
And people, you're right. I think a lot of the lawyers who are subjected to that on a day-to-day basis are angry.
I think so. They're frustrated and not necessarily equipped to deal with these things that they didn't anticipate having to deal with when they decided to pursue the profession of being a lawyer.
And for me and for you, when we worked together, we did a lot of contingency work. And when I was a younger lawyer and I did contingency work, all my cases came from referrals. It was mostly from people that I had worked with, other lawyers that didn't do what I did. That was the source of my business and my income, and it worked out very well. And when I was practicing, let's say when I started my firm in 2009, if you told me in 2010 or 2011 that in order to be a successful plaintiff's lawyer, you had to have a billboard or a television commercial or all this SEO and digital, back then that was sort of looked down upon.
It was taboo.
It was looked down upon. If you had your face on a billboard, then you were sort of considered by some of the upper echelon lawyers as being sort of on the lower rung.
Yeah.
Today, everybody is participating in that, and they have to, because everybody uses, when a client looks for a lawyer, they don't just look for a referral. They go on the internet. They remember what they saw when they were driving on the highway. They remember what they saw when they were watching television in the middle of the night, and that's what drives the business now.
Yeah, well, that's part of the increased competitiveness in the field. And you and I, for years now, have been traveling all across the country to different conferences, different conventions, national ones, regional ones, even local ones. And it's a recurring theme that litigators have had to reckon with, that they must advertise. It's no longer an option anymore. And that's just one of the long list of things that lawyers who go into the profession don't necessarily anticipate having to do.
Yeah, and it can be daunting because you're running your law firm, and then you have to also worry so much about your marketing budget and your return on investment. And it becomes, I think, for any lawyer who's trying to do this in a smaller practice, it's got to be extremely difficult.
That's a very stressful thing, because we both know when you're a litigator, it requires so much focus, so much energy, so much attention that when you're trying to do that as well as bring in business, on top of that, you have to administer the business. When you're doing all of those things, when it comes to that, we talk about some simplicity in running a law firm. Another way of looking at it is that that's entirely more complex.
Because I think it was simple when we were doing it. It's
yes,
gotten complex now.
It's just, and I don't see it changing. Maybe there's some new technology, a lot of software that's become more available to attorneys that helps them run their practice more efficiently. But it's still, I always found that, now going back to something we spoke about earlier, that was something that I don't miss also. Having to be the technician and having to be the business development person, those two things are always difficult, I think, when you're running a law firm, when you have to bring in the cases and you have to run them on your own. That creates a lot of difficulty sometimes, and I think that's something that really exhausts attorneys.
Well, yeah, I always told people that as a trial lawyer, you had to get the business twice. First, you had to bring the case in, but you didn't make anything from that. Then you had to work the case up. So you have to work on that business 2 different times. Whereas in most businesses, the sale happens, you make your money,
right,
and you move on to the next sale. As a trial lawyer, it's completely different. So now, where we were talking earlier about the lack of complexity when we were practicing, if we went back in today, I think we would likely find that the practice has become remarkably more difficult and complex. The money that is needed to run those businesses has become so much greater. Even the cost just of litigation itself, not the marketing aspect, but the cost of litigation itself has gone up so much over time. The cases are taking so much longer because of COVID. So getting paid takes so much longer. All that stuff creates, I think, a lot of stress for trial lawyers.
And these are just more things. I think about people going into law school today. Do they know these things? Because I know that when I went into law school, I knew a fraction of what I knew of what I now know about the practice of law and about the business of law. I have to think that it's somewhat similar. And I think, hopefully through some of our conversations right now, we can open people's eyes who are just, thinking about going into the profession of law. Perhaps there's a lot of other things that they need to consider before they dedicate themselves to this.
Thanks a lot for joining us here at Trials and Tribulations. We're going to be doing more and more of these podcast episodes talking about interesting things both in law and business. So we'd love for you to subscribe, listen on any of your podcast apps, whether it be Spotify, Apple, or wherever else you get your podcast.
Thank you for joining us. This episode was sponsored by LevelEsq.